Good morning, friends. Today we are going to discuss the topic on public interest litigations, a good case against public interest litigation. I am sure you are well aware of the concept of Justice P.N. Bhagavati during 1980s, that public interest litigation, it is the use of law to advance human rights and equality, or raise the actually concern of the backward, minority and disadvantaged people who are not in a position to tell their grievance to the court. So actually this is bypassing the principle of locus standi. That means the persons who are affected, they have to only file a complaint. But this gives under Article 32, after Article 32 the Constitution will tell you about the public interest litigation. So anybody can raise the issue, any social group can raise the issue when it is of broad public interest. There should be public interest, not personal interest. So this concept has been framed, of course it is borrowed from USA, has been framed by Justice P.N. Bhagavati in that famous Hussain Ara Khatun versus Union of India case in 1979. Right? Now it has taken the shape of the reverse shape, and now let us go the antithesis for the same public interest litigation. So now the court has stated that it is cheap publicity interest litigation. Previously, during the COVID-19 time also, our Solicitor General, Sri Tushar Mehta, he asked directly in front of our Prashant Bhushan, please stop the publicity interest litigations. So at that time, public interest litigations, they were termed as publicity interest litigations. Now, Allahabad High Court had added another word, cheap publicity interest litigation. Right. And they have imposed a fine of rupees 25,000 on the advocate, on the person who has filed the so-called public interest litigation. Friends, while disposing the public interest litigation petition number 801 by 2020, in the case of Nageshwar Mishra, is the complainant, Nageshwar Mishra versus Union of India and others, the Honorable Allahabad High Court Justices S.K. Gupta and Shami Ahmad held that this public interest is filed for cheap publicity, and therefore they imposed a fine of rupees 25,000 against the petitioner. Right? So please remember, very clearly the High Court stated that the petition was filed only with the sole motive of gaining cheap publicity, without even going through the provisions of law and law relating to citizenship. Now let us know what happened and what is the origin of the trouble for this patent litigation. This is all regarding the deprivation of the citizenship of Kanhai Kumar. Kanhai Kumar is from Bihar, he is basically a CPI man. He was studying in Jawaharlal Nehru University, Delhi. At that time, during the year 2016, in the month of February, he held a protest. The JNU students, they held a protest, and he has raised slogans, and actually they have supported the terrorists of Pakistan like Afzal Guru, all these people. And therefore a case of sedition and also criminal conspiracy was registered against Kanhai Kumar and others. And since they have raised anti-national slogans, ultimately the Delhi government has taken about 3 years' time to file the charge sheet. At last they filed the charge sheet. Now the case is pending trial. Right? So at this juncture, the petitioner, Mr. Nageshwar Mishra, so he has approached the Honorable Allahabad High Court, saying that he is constrained to approach the court with a request to terminate or to deprive the citizenship of Mr. Kanhai Kumar, as the central government has failed or did not take any action to terminate his citizenship in spite of his giving slogans against our country. So this man maybe actually he has got the national spirit more, right? So during the year 2016, Kanhaiya Kumar and his associates, they supported the freedom struggle of terrorists. Please remember, freedom struggle of terrorist groupers who are working at the instigation of Pakistan. Why? To destabilize the unity and disturb the peace and tranquility of our country. So this petitioner stated like this. So in spite of that, that person, he is not decked out from the country and his citizenship was not at all terminated. He is moving freely. Therefore, the petitioner is requesting the court for cancelling the citizenship of Kanhaiya Kumar under section 10 clause 2 of the Indian Citizenship Act 1945. Right? Now we have to go through the constitutional provisions and also the Citizenship Act. So please remember Articles 5 to 11. Articles 5 to 11 of the Constitution of India tell us about the provisions relating to the nationality or citizenship. Who is a citizenship? For example, Article 5, it says as to how you get the citizenship. Number 1, by birth. 5. Clause 2, by nature. If any either your father or mother is a resident of, or they were born in India, like that. Article 6 says about the people who migrated from Pakistan. Article 7, who went away from here to Pakistan. Article 8, so persons naturally who are not Indian origin but who are of Indian origin but they stayed outside. Article 9, who get the citizenship of other country. Article 10, so the so-called continuation of the citizen rights, whether it continue or not. So therefore he has put this question also. Alright, so please remember basically the laws of when once you are born here, Kanhaiya Kumar was born in India, his parents were born in India, he is a citizen of India. It is very difficult to terminate his citizenship unless under renunciation. If he renunciates, or second is by naturalization. If he goes to the other country and for some time he is there, these are the only conditions. And the third is operation by law. Yes, this is important. Suppose if he is found doing acts against to the state, then definitely he can be externed. His citizenship by operation of law. So anything has to take place. So Articles 5 to 11, they govern the procedure relating to the citizenship. And Act 1955, of course you may be knowing, very recently 2019 Citizenship Act has been amended and it has caused a lot of commotion because the government invited the people of Hindus, Christians, Jains, Sikhs, Parsis from Bangladesh, Pakistan and Afghanistan, and they will give the citizenship to them. Of course it is a controversial issue, let us not discuss about the same. Right, now by virtue of Article 5(1) of the Constitution of India, definitely he is a citizen of India. Right, so the Kanhaiya Kumar does not fall any negative thing. So he was born in India, he is a citizen as per section 5A of the Constitution, article, even as per Citizenship Amendment Act also. Right, now go to section 7. Section 10 provides for deprivation of citizenship of a citizen of India only by naturalization or by virtue of Article 5(1). So let us discuss about the naturalization. You may be knowing, if he goes to other country. Second is renunciation. That means if he takes the passport or citizenship of other country, and definitely he will lose his citizenship. Of course, it is also it is also amended now. Dual citizenship is possible also. So please remember, under no provision of law, his citizenship can be deprived. Only naturalization or renunciation. That's all. You can't do anything. So now, in the present case, so Mr. Kanhaiya Kumar, he was born in India, and as per section 5A of the Constitution, he is a citizen of India. He can't be deprived of Indian citizenship. Please remember, he can't be deprived of Indian citizenship. So, valuable time of the court, which is functioning with limited strength during this COVID-19 pandemic, is wasted by filing such present writ petitions. So, we understand the intention of the petitioner is not to espouse the interest of the public, but only gaining cheap publicity. Therefore, the petitioner is directed to pay a fine of rupees 25,000 in favor of Registrar General of the High Court within 30 days, and it shall be remitted to the Advocates Association. So please remember, before filing any public interest litigation, you have to make it doubly sure that whether there is any public interest in it or not. That's more important. If there is no interest, the court will come adversely, the court will come heavily upon you, and it may impose a fine also. So don't misuse the public interest litigation. Thank you.